You are on You said I can go on. Yes, okay. Good afternoon, ladies and gentlemen. My name is Anthony Obodeze Esquire, a lawyer by profession. I welcome each and every one of us. We are dealing today on business issue concerning registration of business and LLC. Sorry for the technical issues. Just as I said earlier before now, we're talking about the objectives of this course. One, to enable the participant have a basic understanding of the nature of the legal system in Nigeria. Secondly, to enable participants understand the legal regime and regulatory agencies regulating businesses in Nigeria. Third, it will also afford the participant the opportunity of knowing the types of business, organizations, and steps one need to take in formation and registration of business in Nigeria. Then finally, it will also make you understand the basic nature and elements of commercial contracts. We have several topics. One of the topics we'll have for today is the Nigerian legal system. We also have relevant government agencies regulating businesses in Nigeria, types of business, organization, and legal implication the various types of business in business organizations, registration of business organization, law of contracts. We shall be taking this topic one after the other. One, the first is the Nigerian legal system. And before we move further, I think everything borders on law. And for us to appreciate this course very well, we one need to know what law is all about. As a matter of fact, we have different definitions of law. We have different schools of thoughts that define law. But considering the fact that we're going to consign ourselves with respect to business law, we won't bother ourselves delving into all those schools of thought. But meanwhile, anybody who is in this class should first of all advert his attention to what law is all about. Law, what is law? Law is all about just like a body of rules or a principle that governs a particular circumstance. It can be in international circumstance. That's why we have international law, the law that governs international relationship. It might be in economic circumstance that we call economic law, the law that governs the economic circumstance. It might be in business law. It might be in business law. And business law, just like what we are, the main garment of what we are doing today, the law that governs the business transaction, the business relationship between you and your partner in that particular business. This is what law is all about. In every association, in every dealing, there must be a law because that law sets a standard, it sets the principles, it sets a guiding rules upon which everything should follow stricto sensu. Because where there is no law, there should be an anarchy. And that law must govern that set of circumstances. Now, we are going to talk about the sources of Nigerian law. This law, we are talking about law. We all know that this law must have come from somewhere else. That is the sources of Nigeria. Where does all those law, where do they emanate from? One, we talk of common law. We talk of doctrines of equity, talk of Nigerian legislation, talk of customary law, talk of judicial precedent, case law, international law. What is common law? Common law is those law of the English people that evolves as a result of tradition, and it becomes their rules of life, their ways of life. The fact is that many times, most of those common laws
Daddy, want the people to hear you talking. Okay.
No, not now.
Very sorry, gentlemen and ladies, for the network issues. Very sorry about that. As I was saying before, I was interrupted by the network. I was talking about the sources of Nigerian law. I've made mention of the common law, which is the law of England, which we received. I've also made mention of the doctrines of equity. I also made mention of Nigerian legislation. And in Nigerian legislation, I made mention of bylaw. Those bylaws are those laws made by the local council. If it is made by the state houses of assembly becomes law. If it is by the National Assembly, it becomes an act. These are called Nigerian legislation. We also have what they call customary law as a sources of Nigerian law. Those customary law are those laws that are very, very archaic. Those laws that governs the particular customs, it evolves for over years. It is all about acceptability. Once such becomes law, once such is acceptable, it becomes law in that particular society. And what is customary law in society A is different from what is customary law in society B. The most important thing is that that customary law must not be repugnant to natural equity, natural justice, equity, and good conscience. If it is not repugnant to natural justice, equity, and good conscience, it becomes a customary law. And if it is acceptable, it also becomes a customary. And one of the characteristics of it is flexibility and is acceptability. It's also a source of Nigerian law. We also have what they call judicial precedents. Judicial precedent means a situation whereby an issue a matter is instigated in court. When somebody files an action in court and that action filed in court, after the judge must have decided on it, it becomes a precedent. And that precedent, whenever a similar matter is brought again before the court for adjudication, then since it is decided, you understand, by a superior court of law, maybe a Supreme Court, it becomes a judicial precedent. All you need to do is just to make reference to that as a judicial precedent. That is one of the Nigerian legal system. It's also one of the sources of Nigerian law. We also made mention of case law and international law. So these are the sources of Nigerian law. I've also made, I don't know whether I've made it to you, but I have to let you know that what they call received English law. Received English law are those laws that we received from England, which means this common law, doctrines of equity, and statutes of general application that are applicable in England on or before 1st January 1900. These are the received English law and also form part of the sources of Nigerian law. We also have what they call hierarchy of Nigerian courts. As you already know, we have Supreme Court as the highest court of land. We also have court, we have Federal High Court, we have State High Courts, we have National Industrial Courts, Sharia Court, Customary Court, Magistrate Court, Area Courts. The fact remains that, for instance, if a matter is first of all instituted in the High Court, being dissatisfied with the decision of the High Court, one can go to Court of Appeal, you understand, because the person in question is not satisfied with the decision of the High Court. If the person maybe at the appellate court now rules against the person, then the other party can now go to Supreme Court, and that is the highest court of the land. And that's the reason why they say any decision reached by a Supreme Court is final. That is the highest court, and that is the hierarchy of court we are talking about, from the Supreme Court, Court of Appeal, Federal High Court, down National Industrial Court, Sharia Court, down to even Magistrate Court and the area courts. Apart from that, we also have what they call civil law and criminal law. When we talk of civil law has to do with the private rights of citizens and the obligations towards each other. In a situation whereby Mr. A offends Mr. B, or Mr. A trespass to Mr. B, or maybe Mr. A talks ill of Mr. B, that we call it defamation. Those statements that will bring the person, the integrity of the person, below the right-thinking members of the society. In order to defame such a person, it becomes a defamation, and such is actionable. That one is more or less a private.
You don't know where your hand is wet, if not it will spoil.
And if such is done, the person who claims that her right has been infringed upon can maintain an action against the other party. It is more or less like infringement on. So that is what I call defamation. And we also have trespass, we also have assault, we also have act of passing off. These are what are called private laws, call it civil law. It is civil because it is civil. When we come to criminal law, you see the difference between the civil and criminal. Civil in the sense that it has to do with infringement on someone's personal rights as against the right that affects the general public. On the other hand, we can talk about Nigerian criminal justice system, that is crime. What do we mean by crime? Crime means a situation whereby somebody commits an offense. And before one can say that Mr. A commits an offense, that offense must be expressly stated, must be enacted, either by the National Assembly, the State Houses of Assembly, by law, and the punishment must be described. Once such is done and somebody commits it, just for instance, in a criminal code, we have what they call, we have provision for murder. And that provision for murder is to stipulate the penalty. It defines the offense and also stipulates the penalty. In other words, whenever you commit such a crime, it is not an individual that you commit the crime against, but rather you commit such an offense against the state. And it is the state that will prosecute such a person, because it is an offense against the state. And the real essence of such prosecution is to serve as a deterrent to some other person who may be warming up in such criminal activities. That makes it a crime against the state. And that's the reason why we have police, we have EFCC, we have ICPC, Ministry of Justice, Correctional Services. These are the people that prosecute criminal offenses. And it is very, very heavy and weightier in the sense that whenever your matter is called upon in court and you fail to attend court, then the court will issue what they call bench warrant and revoke your bail. You know, as against if it is civil law, that one you might come to court, you may not come to court, the matter will go and then the court will not give judgment. But once it's a criminal offense, it is weighted. It's a very serious offense because it is an offense against the state, because the state has already stipulated the punishment that nobody should do this, and if you do this, look at the punishment. So these are the striking difference between the civil and criminal law. Now we can now talk of relevant regulatory agencies that regulate registration of business, that regulates all these business activities. One, we'll talk of Corporate Affairs Commission, Federal Inland Revenue Services, Central Bank of Nigeria, Asset Management Corporation of Nigeria, AMCON, National Agency for Food and Drug Administration and Control, Standard Organization of Nigeria, Federal Capital Development Authority, FCD, and Commissioner for Lands, Local Government Council. Let's take it in seriatim. One, Corporate Affairs Commission. The question will be, what is this CAC? CAC means Corporate Affairs Commission. It is a body established by Companies and Allied Matters Act. And upon establishment, it has its statutory duties. What are those statutory duties? One, it regulates the registration of business in Nigeria, both business and non-business organizations, such as company, business names, and incorporated trustee under Part C of Company and Allied Matters Act. Like Section 7 of CAMA, that CAMA means Company and Allied Matters are set out. The main functions of Corporate Affairs Commission to include regulation, supervision of formation, incorporation, management, and the winding up of companies. Once a company goes beyond what is supposed statutorily, that goes beyond the MEMAT, Memorandum and Article of Association, then the CAC can swing into action by way of supervising what they are doing, and also they can even make an order for winding up to wind up the company on the ground that the company has exceeded beyond the statutory limit. They can also conduct investigation into the affairs of the company if the situation demands for it, because many times some company upon registration, once a company is registered, they normally have what they call MEMAT. MEMAT means Memorandum and Articles of Association. It is the Memorandum and Articles of Association that states what that company is all about, what will the company do, and what the company will not do. And that's the reason why many times, if somebody wants to access loan, they will ask you, oblige us with their incorporation document. The essence of that is for them to know whether that company in question is sanctioned to do what? To borrow loan. We call it borrowing power as one of the clauses in the memo, borrowing power. And if there's no borrowing power and the bank or any other institution now goes further to issue loan or to grant loan, that bank is on its own, because the MEMAT must have revealed to you that this company in question has no borrowing power, that borrowing power is not incorporated in their MEMAT. And if such is not incorporated, then they cannot borrow. That is the essence of that. And that's the reason why this Corporate Affairs Commission serves as a supervisory role. If the company goes beyond the statutory function, then the Corporate Affairs Commission can swing into action with a view to investigating the affairs of the company. Federal Inland Revenue as a regulatory bodies, we already know that when we talk of, we have Federal Inland Revenue and even State Inland Revenue. Federal in the sense that are saddled with the responsibility of collection and administration of federal and corporate taxes. As we have Federal Inland Revenue, we also have State Inland Revenue that's situated in every part of the states. It depends on where your company is registered. If your company is domiciled here in Abuja, for instance, you pay in Abuja your taxes here in Abuja. If it is domiciled in the East, maybe Anambra State, for instance, that is where you pay. But however, that's what they call transfer. You can as well make a transfer if you want, even though the registered address of the company is here in Abuja and they want to be paying that in Onitsha, there's a procedure for that. We call it transfer. All I know is that all existing manufacturers, distributors, importers, suppliers of goods and services are to register for VAT with the Federal Inland Revenue. All you need to do is just to obtain a form, complete the VAT form, and return to the nearest local VAT office. A A permanent VAT registration number is to be given to each registered payer. So with that, you will be able to remitting your VAT on a monthly basis, and you should also take note that failure to do that, it is an offense. Failure to remit your tax as an window is an offense. However, business that are into the cultivation of unprocessed agricultural products are exempted from VAT and enjoy pioneer status, thus are largely exempted from federal taxes. So the bottom line of all this is that upon registration with Corporate Affairs Commission, they normally give you what they call TIN number. They call it tax identification number. And with that tax identification number is what you use in paying your tax as and when due. And note that non-payment of tax or evasion of that is also a criminal offense, and such is punishable. So it is advisable that upon registration of a company, then you go ahead and do the needful by way of registration of VAT and other things that follow suit. Now, registration with SON as one of the regulatory bodies. What is SON? SON means Standard Organization of Nigeria. It is a sole statutory body saddled with the responsibility of standardizing and regulating the quality of all products in Nigeria. As you already know, without this, you wonder what our products in Nigeria will look like. In other words, we'll have substandard products because there is nobody saddled with responsibility of checkmating what the standard good is all about or what's to be produced. But because of the introduction of SON, Standard Organization of Nigeria, they are on their feet. If you want to produce something, you also take cognizance of the fact that it must have to pass the test of SON, just like the NAFDAC. Just imagine where there's no NAFDAC, you see what will happen, but we'll still come to that place. SON is saddled with responsibility of standardizing and regulating the quality of all products in Nigeria. They have several functions. One, to investigate the quality of facilities, materials, and products in Nigeria and establish quality assurance. They also ensure in referencing standards for calibration and verification of measures and measures instruments. They also compile an inventory of products requiring standardization. They also foster interest in recommendation and maintenance of acceptable standards by industry and general public. They also register and regulate standard marks and specification. They also advise both the federal and the state government on the issue or the problem relating to standard goods, so that those manufacturers, distributors should key in and also should be very, very conscious of what they are producing so that they will not produce goods that are substandard. Some also have the powers of seizure, confiscation, and destruction of standard products, including power to sell off premises where defective products are manufactured and stored. If you think you are very smart that you can produce a good without complying with the procedure set down by some, and upon discovery by them, they have the power to do that, to seize it, even sell it up and destroy the particular premises. So that is the reason why it is very, very necessary and very imperative that you don't need to cut corner. You do the needful. It is for our own sake, it is for your own sake, it is also for the sake of the general public. We also have NAFDAC as a body, as a regulatory body, and you know NAFDAC, as the name suggests, has mandate to regulate and control the quality standards of foods, drugs, medical services, and cosmetics. Just imagine if there is no NAFDAC, if that NAFDAC is not in operation, we wonder what you and I will be eating, will be consuming all this while. backyard, and it's very detrimental to some level of consumption. What it is not, or what is not consumable. As you already know, they have procedure. Once you register a company, then you want to produce something, all you need to do is to make an application to NAFDAC. The essence of the application is for you to do what? To get that particular product registered. They might ask you to bring the product for sample, especially, they normally register in twofold, the food and also the drug. They might ask you to come along with it for them to test in their lab. After they must have tested, they will require some documents. They will require you of some document of registration. That is a Corporate Affairs Commission document, which must accompanied by other different documents and must be authenticated by a legal practitioner. Upon doing that, then they will, if they found their documents worthy, they will go ahead and register that particular product. The requirements are generally similar. Both drug and specific requirements can be obtained from NAFDAC office across the country. All you need to do is that once you have a company, and once you want to register for a particular product, all you need to do is just dash into a NAFDAC office with a view to obtaining the requirements, which if obtained, then you now comply strictly sensu. They will get your product, either food or cosmetic, registered. It is better, it is also advisable to do that as against cutting corners, because if upon being caught, definitely you are going to pay through your nose, and it will not be good for you and for the entire public. Now we'll come into types of business organization and the legal implication of the various types. The first question we'll ask are, what is business organization? Business organization is just like a legitimate, a legal way of making profit. There are some people that make profit in an illegal way. There are some people that make profit in an immoral way, but this one is just like a legitimate venture to make profit. And as a matter of fact, we have different types of business organization. We have the one they call sole proprietorship, we have partnership, we also have company. We're going to take in seriatim, starts with sole proprietorship and its legal implication. Who is a sole proprietor? A sole proprietor is a person who just wakes up in the morning and decides to open a business by himself. It's just like a one-man squad. He has just decided to open a business, and it has advantages and its disadvantages. One advantage of it is that everything that he makes, all the profit that he makes, he takes it hook, line, and sinker. It is profit. But one disadvantage of it is that if in the course of doing that business and he now incur debts, you understand, he will be personally liable for that. In other words, if he has a personal property, that property will go in order to offset the debts in question. A sole owner is personally liable for the debt and liability of his business. Personal assets like car, properties, personal houses of the owner may be seized to offset the debt of the business. The business, even if registered with CAC, is not separate legal personality from the sole owner, because the sole owner had decided to open up that, to run that particular business. He does it on his own. So whatever risk that comes in, he will take it himself. Whatever profit that comes in, he will also take it. And that's the reason why they say that it has issue concerning successor possession is not applicable here. Once the person dies, that business dies automatically. There's no two ways about that. Once it dies automatically. Then we'll also talk about partnership and its legal implication. When we talk of partnership is when 2 or 3 persons agree to embark into a venture. You understand? And most of the general partnership are not registered. And if it is not registered, Such partnership is a general partnership. And you also, the liability is also on liability. You understand? On liability in the sense that if in the course of doing that business, they now incur some debts, then, and what they have in common cannot offset it, they can now go extra mile to sell their personal property to offset that particular debt because it is unlimited. It is unlimited. That is what they call partnership business that is not registered. This takes us to what they call companies, registration of companies. Just like what we have discussed now, we have sole proprietorship, we have partnership, we also have a company. What is a company? Because people have been saying company, and they don't know the legal implication of company. The legal implication of company is that once a company is incorporated with Corporate Affairs Commission in accordance with Company and Allied Matters Act as contained in Company and Allied Matters Act of 1990, once incorporated, it becomes a body corporate. It becomes a body sole that can sue and be sued. In other words, it becomes a separate body because once it's incorporated, you have directors, you have shareholders. The real essence of that of this registration is that once it's registered, that company is a distinct body from those directors. In other words, that company in question can be sued outside directors. Because it is an artificial body, it can operate through directors. But if the company, if a contract is executed in the name of the company, and maybe in the course of the execution, they now incur debts, in such situation, it is the company in question, XYZ companies, we are going to maintain action against, and not against Mr. Bernard, who is the director of the company. That's the reason why we say it is a common principle of law in Solomon and Solomon that once a company is registered, it becomes a corporate sole who can sue and be sued in its corporate name. Now, they can also buy and also own properties. They can also enter into a company, can sue and be sued, enjoys perpetual succession. In other words, they can live forever. If Director A is deceased, if Director A is no more to be found or has decided to exit from such a company, then by way of resolution, they can now appoint another director and the company continues. As again, when it is a sole proprietorship, such a person dies, the property, everything, the business dies automatically as against this particular company. Once Director A dies or Director B dies, the company name is still there. The other director, by way of resolution, they can take it up and move ahead. This is the major difference between the company and that of sole proprietorship. Registration of business and non-business organization. Why register your business? It is very, very important for us to register our business because once a business is registered, just like what I said earlier, it becomes a corporate sale. In other words, you can use it to do business. You can use it, that particular business name, to borrow loan. You understand? You can use it to borrow. You can use it to access loan. You can use it to access facilities. Even if your brother is a minister and you don't register your name, I find it difficult how that you are a brother who is a minister for labor or maybe commissioner for works. I doubt how the person will give you award contract to you because they cannot award contract to you as an individual, but rather they will award contract to you as a company, duly registered, duly incorporated with the Corporate Affairs Commission. That is why it is very, very essential that you do well to pick up a name, get it registered, do business with it. You can apply for loan, you can apply for facility, but with that name. The fact remains that unregistered business with Corporate Affairs Commission is unknown in law and therefore cannot transact some official businesses like borrowing from a bank. There's no bank that will want to borrow you or lend you money without you obliging the bank with what they call certificate of incorporation. This is the rudiment. If you don't have it, all you need to do well to get your company registered. It is very, very important. And after you had registered, you also do registration of tax. The law is that upon registration within 6 months, you are exempted from tax registration. All you need to do is just a POL, they call it pre-operational levy. Upon payment, or they'll give you tax certificate, tax clearance certificate to that effect. But if it's beyond a year you register, then definitely you are going to follow the procedure to get your, which you know the procedure is not all that is quite cumbersome, and also it involves money. But if you register a company, the first thing you should do, register with FRS. Second thing, the tax issue for, so that they will be able to issue you with a tax clearance certificate. Small business startup procedure. All you need to do, just find a suitable business name to support your business idea, identify suitable business location, register the business name with Corporate Affairs Commission. Make sure you choose a name that is easy to pronounce so that you won't forget the name in question. Register with FRS, value added tax VAT, register your product with NAFDAC, register with SOM. Once you do all this, then you are good to go. You are good to make profit. You are good to make an application for loan, access facilities in any bank you think of. Procedure and document to be submitted to Corporate Affairs Commission. One, you should know that if you want to register a company, first of all, that's what they call name search. Name search means you put in an availability to know whether the name you've chosen, whether that name is available. Because the law is that if the name in question is not available, it is not available for all intent and purposes. But if there is any existing name that is similar to the name that you want to register, the Corporate Affairs Commission may deny that particular name. The reason is that there is an existing name which is similar to the one you intend to register. And if they register the one you intend to register, despite the fact that there's an existing one, that it has a proclivity, the tendency of misleading the general public. So by virtue of Company and Allied Matters Act, Section 31, it says that once there's an existing name and that name in question is similar to the one that you intend to register, then the CAC has a right to do what? To decline, to deny that particular name. So that's the reason why once the name is approved, they give you like 60 days. The essence of 60 days for enable you do the needful and get that particular name registered. After the expiration of the 60 name, if you're unable to get it registered, that's what they call revalidation. You will now apply for revalidation to revalidate a particular name. And once all these things are done, you need to submit notice of their approval, duly completed business name application form containing the personal details of the proposed proprietors, if it is a sole proprietor. Status now state the nature of the business, information page of the nation, that is a means of identification, 2 passports, photographs, evidence of payment of filing fee. Once these are done, you are good to go. You are good to go. And the same thing applies to company and also incorporated trustee. Incorporated trustee, that is under Part C, is all about churches, it's all about organization. When you register that one, you register under Part C as against limited and the business name. Procedure and documents to be submitted to CAC for registration of a company. Just like what I've already said before, all these documents, first of all, you have to submit the document of reservations. And if it is limited, just like the one we did before, is the one I just spoke on now is on the issue that borders on the sole proprietorship, but this one is limited, and they are almost the same thing. So, and the company may either be private limited, or you can call it a public liability company. A private limited will have share capitals, we have shareholders of about 2 to 50 persons, but public limited is from 2 to unlimited. There is no restriction Public limited companies are usually quoted at the stock exchange market and highly regulated by the SEC. SEC means Security and Exchange Commission, like Dangote Sugar, Dangote PLC, and all those things, Zenith Bank and the rest. They are public liability companies. They hold their shares at the international market. The first step to take in registration is reservation of the proposed name, which I had earlier on said. Once it's reserved, then you can now proceed with the proper registration by filling all the necessary documents, supplying the CAC with the photocopy of the means of identification, which might be that driver's license, national ID card, then voter's card, and all sorts of means of identification. So these are the things, and the memorandum and articles of association duly stamped upon presentation of all this before the Corporate Affairs Commission, then you are good to go. Law of contracts. What is contract? Contracts is enforceable legal obligation agreed upon when 2 or 3 persons agreed on 2 or 2 things. That is contract. And we have elements of contract, that are features of a valid contract. You have what they call offer, you have acceptance, you have consideration, the thing of value exchange. You have form, you have capacity, you have legality, and also intention to create a legal relationship. You have what they call privity of contract. What is privity of contract? Privity of contract means party to a contract. Party to a contract. Who are parties to a contract? If you are not a party to a contract, you cannot benefit from such a contract. And if you're a party to a contract, you will benefit from such a contract. And that makes it a party, that makes you a party to a contract. And they call it privity of contract. We also have to call terms of contract. You have express terms and implied terms. What is express term? Express term is in a contract agreement where parties agreed on terms and conditions, and it will be expressly stated. It will be expressly stated that if this happens, this will happen. If this happens, this will not happen. That is what they call express covenant, as against what they call implied. Implied means that you should have known that if this one happened, the other one will happen. You understand? But it will not be written down. It is when it is written down in a clear terms, it becomes an express terms. And that express is very, very good. It's very, very, because it saves you from a lot of argument. It saves you from a lot of arguments. Then we also have what they call vitiating elements in a contract, something that can invalidate a contract. We have duress, you have undue influence, you have misrepresentation, you have mistakes. What is duress? Duress means in a situation whereby out of force, maybe Mr. A was forced by Mr. B to enter into a contract. In such situation, Mr. B, who entered into such contracts under duress, can now rely on that duress to frustrate that contract, to vitiate that contract on the ground that ordinarily ought not have entered into contract, if not for the duress, or if not for the undue influence, because Mr. A has undue influence over him, that if he enters, look at what belongs to him in future. If he doesn't enter into a contract, look at what he stands to do. They will call it undue influence. Based on that, he now enters into contract. That contract can be vitiated on the grounds of undue influence. The fact remains that before you enter into a contract, there must be what they call consensus addendum, meeting of the 2 minds. The 2 minds must have met with a view to entering into a contract, and it must be free and voluntary, and not something somebody can just force you into. The misrepresentation, when you misrepresent fast to Mr. A to believe this, that at the end of the day, Mr. A now discovered that you, if not for such fraudulent misrepresentation, that he wouldn't have entered into such a contract. Such contract can be vitiated on the grounds of misrepresentation. Mistake, if there is a very serious mistake that goes, a fundamental mistake that goes to the root of the terms and conditions of the contract, and on that grounds of mistake, such a contract can be vitiated. discharge of contract. We talk of performance when a party must have performed. You know, one thing with contract is that contract states terms and conditions, states obligations on the part of party A, state obligation on part of B. B must perform its own obligation, A must perform its own obligation. You understand? Then we talk of frustration. These are the discharge of contract. When we talk of frustration, frustration means the situation whereby, as a result of frustration, the contract is discharged. If not for that frustration, the contract ought not have been discharged. Fundamental breach. If either of the party breach the fundamental terms of the agreement, you agree with me that before you enter into an agreement, parties must agree on terms and conditions, and most of those terms and conditions are fundamental terms. And those fundamental terms that goes to the root of the contract must be complied with, must be honored, must be observed. Failure to observe those terms, it results in what they call breach, and that breach will now discharge that particular contract. And those who mutual agreement, parties can now decide that no, we don't want this agreement again. Look at this, look at that. Based on that mutual agreement, they can discharge the contract. Remedies for breach of contract. In every breach of contract, there must be the damages, or what we call compensation. When two or three are gathered and agree on terms and conditions, and Mr. A performed, Mr. B performed, Mr. C failed to perform, it becomes a breach. And once there is a breach, there must be a compensation for that. The other person may be compensated, or they can ask you for what they call specific performance. Because Mr. A has performed his own, Mr. B has performed his own, then Mr. C has not performed his own part of the obligation. The court may make an order for what they call specific performance, that Mr. A must do what specifically perform his own parts of the obligations. Then rectification. To rectify means, as in, if there is a mistake or maybe something like a clause in an agreement which states one or two things that is not all that correct, or based on that, they can be rectified. That's what we call rectification. Then on the issue of injunction, if a party fails to do what it's supposed to do by observing its own terms and conditions of the contract, then the court has the duty to make an injunction. Injunction means an order of the court mandating such a party to do what it's supposed to do specifically. And there's only what I call quantum merit. Quantum merit means because the terms and conditions are usually they normally measure it on the basis, on a scale, kind of, this person has performed 50%, this person has performed 50%. They can now ask you to perform your own based on the quantum merit. That's what they call quantum merit, on the basis of that terms and conditions of a contract, and also rescission. These are remedies for breach of contract. It can be rescinded. Then with this, we are done with what we've just said earlier before. Registration and this compliance question, we'll proceed from there. You're listening here. Hello, Mr. Chubo Moses Ogbe. Afternoon. Do you have any question to put across?
Hello, sir.
Yeah, I'm listening.
Okay. Well, for now, I don't have any question. What I wanted to ask before was discharge of contracts. That you made mention of frustration and some other bullet points. But
Yes.
in the course of explaining it, I got what you mean, discharge, like to acquit the contract based on frustration, but I think I'm fine with that.
Yes. Thank you.
Is that right, sir?
Yeah, thank you very much. Juliana Chinenye Onibo. Good afternoon. Hello, Juliana Chinenye. Hello, Juliana, do you have any question? Remove your headpiece. Remove. Do you have any question? Unplug your earpiece. Unplug it. Your earpiece, yeah. Unplug.
No, she needs to unmute her mic.
Hello. Hello. Do you have any question?
No, not at all, sir. I'm trying to unmute the mic.
Okay. Sharon. Sharon. Hello, Sharon. Sharon, do you have any question? You don't see her from here.
Next time. But that guy now, Milan, no be saying anything.
Neka. Simeon?
Yes, I have a question, sir.
Yeah, okay. What?
I have a question.
Okay, please do ask.
Okay, thank you very much for the nice session today. Okay, my question is regarding the FIRS tax. You mentioned that, yes, if a company is set up, you are supposed to be paying a tax every month, supposed to be remitting every month. So I want to ask, in a situation whereby you set up a company and let's say for up to 6 months, no business activity now for transactions. So if FIRS come now, will they compel you to pay for those months, or you are not supposed to pay for the month that there was no transaction? How does it work?
Okay. Your question is well understood. Your question is, in a situation whereby one has registered a company and that company has not commenced business, will the person pay for that year? That is your question. With respect to FIRS, but while answering the question now, I'm going to diversify to even Corporate Affairs Commission. Now, once you register with Corporate Affairs, let me start with Corporate. Once you register with Corporate Affairs Commission, then you are supposed to file what they call annual returns on a yearly basis. That annual return you are going to file on a yearly, whether you have commenced business or not, and that's why they call it annual return, because you have not commenced business. Once you commence business, it becomes an audited account of that particular company. So you file annual return for every year. You file annual return. And when it comes to FIRS, value added tax, that is VAT. The law is that you file that VAT on a monthly basis. You file on, all you need to do, you can get a tax consultant who will further educate you on that. Assuming you incorporate a company and that company has not commenced business, or even if you commence business, there are ways to go about all those. It's not when you make million, you file million. There are some goods that are not taxable. There are some certain materials that are not taxable. It is the duty of the tax consultant, your own tax consultant, to work it the way at the end of the day you will pay something into the purse of the FIRS without paying much. But if you fail to do that, when they come on their own, you know, because they normally give what they call self-assessment at time. But when that one fails, they can now come on their own and they do the needful. And if such is done, definitely you are going to enter into their trap. So the point I'm trying to make is that when you get a tax consultant will be in a better position to advise you what are taxable and what are not taxable, so that they will prepare it in such a way that upon filing it, you won't have any problem. But bear it in mind that every month that you are going to file VAT, you are going to file VAT returns. And they are very, very technical. They are very, very diplomatic. The essence of that is that when you file that, say, I have not commenced business, they will keep it. You file next month, you've not commenced, they will keep it. A day shall come when you will be confronted with those things you've been filing, because they may at times request the statement of account. And once they request for the statement of account, and behold, the statement of account states amounts of money comes into your account within that period of time you've been filing that you've not commenced business, that is an inconsistency. And how do you reconcile with that inconsistent situation? That's the reason why necessary you start with discussing with the tax consultant, who will now educate you more on that, because they are very, very smart. You might think they are not smart, but they are smart. So that is my answer to that question. Thank you very much. Thank you. Okay. The internet connection is unstable. Silas, do you have question?
Thank you very much, sir. Good afternoon.
Good afternoon, Silas.
The presentation has been wonderful, and great appreciation to what you've made available for us. With respect to having any question, for now, I don't have any question because it's very, very self-explanatory with the way you presented it. The question the last lady asked, I think I actually have, it would have been a question I would have asked, but for the fact that you asked it and you've answered it, I think that has sorted it out, because this filing of returns to CAC, I think I've not done that for years. And for IRS, FIRS, that's inland revenue, inland revenue. Between the periods I incorporated, I was not on business, so the tax clearance that I have is not updated. So I think the information that I got with getting to get an updated tax clearance, even if I was not in business, there is a specific amount I'm supposed to pay every year. So when they sum that up, it's not that small. But, thank you very much. It's been wonderful. It's been good. And thanks.
Yes. In addition to what I've answered, in addition to the answer, the reason why it is very, very important, very, very necessary, by most especially with Corporate Affairs Commission, is that if you fail to file at Corporate Affairs Commission for 30 years, they also have the right to do what? To delete your name from the system. You can see how embarrassing it will be. Maybe they award the contract to you, maybe you present the document before an organization, they said, okay, let them go and conduct search. On reaching there, they discover the name has been deleted because you've not been able to find your annual return. You see how embarrassing it is. So what I advise you to do well to get a lawyer, then you will file your annual return as and when due. Thank you very much. Any other question from the floor?
Hello, sir.
Hello?
I want to ask, does this apply to a business name as well?
Yes.
Does the exact situation, or are there some exceptions?
No, there's no exception at all.
Okay.
There's no exception at all.
It's all right.
There's no, even a church, this IT, Incorporated Trustee, there's no exception.
It's okay, sir.
Any other question? Okay. Okay. Xperia.
Yeah, it's the comma thing. What does it stand for? Allied, what does the C stand for there, the comma?
Company and Allied Matters Act. Company and Allied Matters Act.
Right. Thank you, sir.
The one that established Corporate Affairs Commission.
Thank you.
Okay, sir. Any other question? I think in the absence of any other question, I thank each and every one of you for having enjoyed this afternoon lecture. And let's get prepared for our quiz, post-lecture quiz. So stay tuned. Thank you. Stay tuned.